Namaskara. Welcome back, viewers. Welcome to another exciting and informative session with the team of Kalpavruksha. The previous episodes, we discussed in general about mediation and arbitration. Today, we are going to analyze what arbitration is in detail. To help us with this task, we have Mr. Prashant Chandra with us to facilitate this information. Mr. Prashant Chandra is a veteran advocate practicing in Bangalore and is involved in a lot of mediation and arbitration cases across the country. He has also authored numerous books with respect to arbitration and the Commercial Courts Act. Welcome, sir. Namaskar. Sir, my first question to you would be to educate our viewers as to what the concept of arbitration is.
Thank you, Abhay. What arbitration is? If you ask me in one word, it is nothing but the privatization of the courts where the dispute resolution is given to the arbitrator. Arbitrator is a judge who is a private judge who, by the consent of the two parties, becomes the arbitrator, gets appointed as the arbitrator, and the dispute resolution of the two parties is being adjudicated by him. It is the same as the court, but done by a private judge in a private place with the private parties where they agree to appoint a common man as a neutral third party and arbitrator, and he renders the award, which is the judgment.
So then what would be the benefits of arbitration when compared to courts? Because as you're aware, when we go to the courts knocking for justice, unfortunately, because of the pendency and the volume of cases that are before the courts, the time taken for a resolution is very long sometimes. So what is the benefit of arbitration of just privatizing the courts?
See, the court, as you said, is flooded with cases. Court has to deal with variety of cases, including cases which are of commercial in nature. So the commercial parties are the parties where they have a contract between themselves, I would say. They would prefer to have quicker and effective justice. So they may prefer to have it in place outside where they would get a quicker attention to their dispute and time to resolve, which is faster. So these are the areas where certain disputes can go to the arbitration by choice of the parties. Please note, the consent of the party is a must. Consent can be in very various forms. If a party, I would say a trade body, he is having an understanding with another trade body, maybe it is something to do with some trade transactions. They may have a regular contract. In the said contract, apart from other terms which they have regarding their negotiations or about the terms and conditions, they may also add one another clause to say, in the event of a dispute between the two of us for any reason, any differences, we would prefer to go for arbitration. So the consent between the two bodies, two parties is a must for arbitration, and by that they exclude themselves by consent to go to the court, and they agree to go to the private court, namely arbitrator.
But sir, big companies have legal teams to draft contracts and enter into formal contracts. Smaller companies, a lot of people don't even draft contracts but start business transactions. So you're telling me if they don't have a contract that they cannot go for arbitration or take the advantages and benefits of arbitration?
Good question. I said that there has to be a dispute resolution clause for an arbitration.
Correct.
Sometimes there may not be any agreement, as you had rightly said, or they may not have contemplated a dispute. Nobody would think of a dispute when they are entering into a contract.
Yes.
Nothing prevents them even to go to the arbitration at that level. When they identify that there is a dispute, by maybe exchange of notice or by exchange of some other letters or some conversation between the two, they realize that there is a time, that the time has come to take the matter to the court. At that time too, they can agree to go to the arbitrator by consent. What I meant to say is consent is a must for arbitration, and that can be pre or post.
So when you say post, after I go to the court, is it possible for me to stop proceedings before a court and say that we want to go for arbitration to shorten the time of litigation?
I would split it. After the court also is possible, that I'll answer later. Okay. Before the court, before they enter the court, a party can always request the other party. Now that we have differences, the dispute has emerged. I would like to opt this matter to the arbitration. Will you agree?
Okay.
If he says yes, then both agree for the platform of arbitration. Then the next question is the choice of the arbitrator. That also they can agree. By consent, they can say, let us appoint A, or it can be A, B, and C. So both, if they agree on the appointment of the arbitrator and the platform of the arbitrator, they can, even before going to the court, opt for arbitration. That means they are excluding from the court. Now we'll assume a situation where there is no clause, there is no consent to go for arbitration before.
Correct.
If a matter is already filed in the court, and after the notice to the other party, and if both parties are in the court, that time too they can, by consent, as also by the consent of the judge, that is to say order of the judge, can agree to go to the arbitrator. That's what the new law is, that is to say section 89 CPC, where it says that the court also can refer the matter to the arbitration. So what you said, that answer is yes, it is possible. I would put it this way: before agreement, because of a clause; during the dispute, because of a understanding; or after the dispute is filed in a civil court, by consent of the parties, matter can go to arbitration.
So you're saying that the underlying principle is there has to be consent of both parties to go for an arbitration. One question would be, can the courts force two parties to go to arbitration to reduce the burden on the court so that they can focus on disposal of matters?
No, the court cannot force a party. If the matter is already in the court, where there was no such agreement prior, then the court cannot force, it can only request the parties. If once the parties agree, then the court can say you can go to the arbitration, not otherwise.
Sir, what would be the timeline generally for arbitration? Because for courts, a simple eviction suit goes for 5-6 years. So what would be the general timeline in an arbitration proceedings to conclude?
See, ideally, if you go by the Act, we are all governed by the Arbitration and Conciliation Act 1996. It has made certain amendments also. And if you go by that, ideally a matter could get over in 6 months or maximum of 1 year. But there are some cases which are, for various reasons, getting delayed beyond that. But if you generally ask me, it would be a year of 1 year is a reasonable time for the parties to find a solution.
That is a good
yes.
time. So.
As against a system where in the court, as you rightly said, it could be minimum of 4 to 5 years.
Correct. True. I agree. Yes. Sir, what type of cases are permissible to be referred for arbitration? Can anything, including criminal matters, civil matters, what type of cases can you say can?
Criminal matters cannot go to the arbitration because there cannot be any consent for adjudication there. It has to be by it's an offense of the state.
Against the state. Okay.
So naturally it is a state which is involved, namely the Department of the Police, prosecution or whatever it is. Therefore it cannot be arbitrated. It cannot be compromised also rather in the court. I mean, even to refer to arbitration, it cannot be done. Other than that, matrimonial cannot be because it has to be only by the court, namely the family court. Now, even the law regarding, the relationship regarding landlord and tenant, the Supreme Court has said even that can be arbitrated, eviction order can be passed. All contractual matters between the parties who are commercial or individual or both commercial, all these matters can go for arbitration. It could be for recovery, it could be for damages, it could be for declaration. All that matters can go. Construction disputes, then bank disputes. Of course, bank disputes, if it is beyond a particular limit, namely 20 lakhs, then it has to be compulsory to the debt recovery tribunal. Less than 20 lakhs, it can go to the arbitration by consent of the parties. That is, there are quite a few things.
Sir, now that real estate value is going up, partition suits are coming up in huge numbers. Are those also one of the cases that can go for arbitration?
Certainly, they can also go for arbitration.
Okay, that is good. Sir, if you could help our viewers understand, how is the procedure of arbitration so that they will know what happens?
Procedure is very simple. What the both parties agree becomes a procedure. If there is no procedure agreed between the two of them, then the procedure is informed by the judge, namely the arbitrator.
Okay.
If there is a consensus with him, then that becomes a procedure. Unlike in a court where whether you like it or not, you have to pass through the various stages of a hearing. In an arbitration, you can skip and go to the procedure which you require. For example, we have some cases where voluminous records are produced. In a court, it could be, it takes time to get those things marked, evidence being led. All that can be avoided by consent of the parties. Because in arbitration, most of the documents are known to each other. There is no surprise.
Yes.
My documents are known to my opponent. So those documents are already in the sphere of the other side. They just give a mark it and say by administrative this thing, they mark the document. They may say in this matter we feel that there is no need to go through the evidence. They can straight away argue. Interpretation of a clause in a contract, sometimes it doesn't require any procedure. What they want is a third party arbitrator to say this clause has to be understood this way. That's all. So it can be over in 3 months. Straight away they can argue on the interpretation of the clause.
So would it be right for me to say that if you have a choice, then an arbitration should be explored
Definitely.
at all possibilities?
Definitely. I would put it this way, Abhay. You have a road, which is the road from, say, I'm talking of the highway, which is a congested road. Now the government has provided you a flyover by the side of it, and if you can afford to go by the flyover by paying the toll fee, you opt for it. So arbitration is a sort of a flyover which is given where you can opt to the flyover without getting into the congested road.
But if that is the case, is arbitration more expensive than a regular courts?
It depends. There are some institutions which are also doing arbitrations. We call it as institution arbitrations, where the fee is prescribed. That is to say, a value is quantified. On the quantified value, a particular fee is described, defined. It is only limited to that. Whereas in some arbitrations, it may be not specified, so it may be varying. Another advantage is there is no court fee payable. Because in a court, you must pay the court fee, then only the court entertains a petition or a suit. Here, it is by consent of the two parties, both of them will equally pay it. That is to say, if 10,000 rupees is the fees, it is shared by two parties. So it is that way dependent on what is the... Secondly, the big difference is this. In a court, there are several cases, including your case.
My case, yes.
So the judge has to find time for all these cases, and which very difficult. You may get 5 minutes quality time there.
So, yes.
Here, it's only your case.
One person handling. So
And for 5 hours, 6 hours a day. Which means a lot more progress is made in one day as compared to the court where it may not be even minimal. So that makes all the other disadvantages covered up.
Thank you, Mr. Prashant. This was really an informative session for myself as well as for our viewers about arbitration. So viewers, today we have learned a little bit more about arbitration, how it is to be done, the effects of arbitration, the benefits, and also the timeline. We thank Mr. Prashant for helping educate on this aspect. Viewers, stay tuned for more episodes to understand the various benefits of the other alternate dispute resolutions. Please note, alternate dispute resolutions help you save time and money in resolving all your issues. Thank you.